The Attorney General said the MRA is known for calling it like it is. And in that vein, we have presented to Professor Kovach a white paper that's in front of you. And we'd like to get his opinion on it. And I would like, since Darren Chappell was good enough to write this, I would like him to explain it and phrase the question, if you would, Darren.
Well, first of all, I appreciate the opportunity. The more of a thumbnail sketch of what I would like for Professor to address. My particular area of study is American federalism, the issue of states' rights as they relate to the Constitution as a social contract, more so than perhaps a legal perspective. The idea that I've tried to address here is the concept of, based on the 14th Amendment and due process, that in 1892, the United States sued the state of Texas over the issue of the border between Texas and the then Oklahoma territories. And the United States appealed to the Supreme Court to exercise its prerogative of original jurisdiction to hear the case immediately rather than allowing it to go through the appellate process as it would otherwise normally do. What I would argue is, and what I'm asking the doctor to speak upon, is whether or not, first of all, this is a viable option, and secondly, is this something that we should pursue given the fact that should, heaven forbid, something happen to Justice Scalia or Justice Thomas or whomever else on our tentative hold on the court when we, on a fortunate day, get a 5-4 ruling our way? Do we want to try to push this so that the Supreme Court hears this sooner rather than later, knowing that one more opening on the court could very well give President Obama an opportunity to have his ideas of jurisprudence reign supreme for the next several decades?
Well, for those of you who aren't familiar, this is a great paper, and it's an interesting issue. Article 3, it's here in the second paragraph. Article 3, Section 2, Clause 2, lists the jurisdiction of the Supreme Court of the United States, and then the inferior courts of the United States are not actually created in the Constitution. They're just referred to as such inferior courts as Congress may create. And it says that the Supreme Court has original jurisdiction in cases involving a state, and that's clearly what this is. As Darren undoubtedly knows, that initially you could argue that the Supreme Court must take the case, that it is the only court of original jurisdiction when a case involves a state. But I would say, unfortunately, that was not the decision that the Supreme Court took when the question was first presented to it, as to whether this is an exclusive original jurisdiction of the Supreme Court. In other words, can you only take cases? In other words, is the Supreme Court the only court of original jurisdiction, the court where the case starts, when the case involves a party who is a state? And the Supreme Court said no, it's not exclusive original jurisdiction. The lower federal courts can also have original jurisdiction in these cases. I think actually if the state of Arizona had exercised the option you suggest right at the beginning, I think it would have been a positive thing for the reason you suggest, that right now we have a Supreme Court that I think will uphold Arizona's law. I think there's a very good chance that when the case gets there, if the case gets there, that they would uphold it in total. They might, see one or two provisions as perhaps, the law has lots of moving parts, but I think they would rule in our favor. Now I think the ship has probably left the dock because the lower court has already issued a ruling on the preliminary injunction motion, and the state has already appealed it to the Ninth Circuit, and indeed the briefs, we finished our briefs, and I'm serving as consulting attorney for the state of Arizona, so I'm chipping in on the briefs. I'm not in the driver's seat. The governor's office is in the driver's seat, and the governor's council is, but they're taking my suggestions and advice and how to shape the brief. They've already, the state has pretty much consented to the original jurisdiction. It has consented to the original jurisdiction of the district court for the District of Arizona. So I think it would be too late at this point to take this path just because the state of, but I think at the very early stages they could have, and one might argue should have, The only counterpoint to that is that the case was already incredibly complex and highly charged and politicized. So if the state of Arizona then said, okay, look, we're going to throw another big issue on the table for you, we think the Supreme Court should take this case, and we're going to, argue that the court should exercise its original jurisdiction, it probably would have added. It would have been, if I had tried to persuade the state to take that approach, it would have been a hard sell. I think that the sense was that this was a very complex case already, and it would have complicated it further. But I think there's a lot of good, you lay out a lot of good reasons why this would be a good example for the Supreme Court to exercise original jurisdiction.
Would this be something the state of Missouri could